All rise. First District Court of Appeals now in session. All who have business before this court, draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good afternoon and welcome to the First District Court of Appeal. We have one case on the docket today, Cynthia Craven versus the state of Florida. Counsel, after the argument, you're invited in the rotunda to join the panel for coffee. And with that, Mr. Cox, if you're ready, you may proceed.
My name is Henry Cox with Bedell, Ditmar, DeVault, Pillins, and Cox firm in Jacksonville. Here representing the appellant, Cynthia Craven, on direct
Mr. Cox, will you just pull the mic a little closer?
Certainly.
Thank you.
I apologize. On direct appeal from a judgment of guilt for aggravated battery, which arose from a jury verdict in Suwannee County, in the Third Circuit. If it's all right with the court, what I would like to do is reserve 6 minutes.
You may.
And if it's also all right with the court, I would like to go immediately to what is identified as issue 2.
Certainly.
Appeal. I say that because it may be characterized somewhat as an elephant in the room, because we are not oblivious to the Boston decision of this court. We're not oblivious to Judge Roberts' concurring opinion in Mency. And if you track the chronology of this particular case, it begins with, and if I use the term stand your ground interchangeably with self-defense immunity, I apologize, but it's used so much in this case. With the hearing in the trial court on the defense motion for defense immunity claim, a trial judge's decision overruling it, a direct review of that decision by petition for writ of prohibition before this court, a denial of the petition for writ of prohibition by this court, and then it returned for trial. And as was said in the concurring opinion in Mency, once there is a denial at the trial level of a motion for self-defense immunity, there are 2 options available. One can seek writ of prohibition or one can go to trial. In this particular instance, both options were elected and both were unsuccessful. So the question would become, well, then why are we here? And I would suggest that we are in a different posture with this case now than we were when it first came to this court on the petition for writ of prohibition. And Judge Thomas wrote that decision. One significant event took place before trial after this court ruled, and that was the defense filed a motion in limine, or filed several motions in limine, but motion in limine number 1 separated what happened in the first set of circumstances from this right now. In that particular motion in limine, what was requested that no non-witness be permitted to testify or identify or comment on what was on the video in this particular case. I believe one of the members of this panel served on the original panel that wrote the, or participated in the writ of prohibition. In that particular case, when it was remanded for trial, the court specifically granted the motion in limine and said, and I quote, it went beyond saying motion granted, it said, quote, non-eyewitnesses will not explain, comment, narrate, or otherwise discuss the contents of any video of the incident and will not make any statements touching on guilt or innocence. We believe, and despite the appellee claiming that certain errors were not preserved on this particular issue, in part, we would rely on Section 90.104(1) of the Florida statutes, which says that when the ruling is one excluding evidence, the substance of the evidence was made known to the court by offer of proof, or excuse me, let me restate that, I'm quoting the wrong language. If the court has made a definitive ruling on the record admitting or excluding evidence, either at or before trial, a party need not renew an objection or offer of proof to preserve a claim of error for appeal. In this particular instance, there were 2 objections that were raised. One was sustained, one was overruled with respect to the prosecutor narrating what she claimed was on the video. We identified in our initial brief, and I believe I could go through several of them now, examples of where the prosecutor was saying, either with a witness on the stand or a closing argument or an opening statement to the jury, you will see on the video. What that does is much like one of the cases we cited, which is Alvarez. It enhances for the trier of fact. In Alvarez, it was a jury. It enhances for the trier of fact a non-witness's representations to a jury that there must be, it must be on there. We don't see it, but it must be on there. And I want to highlight two particular examples that I will represent are not visible on the video by anybody, and that is Ms. Craven picking up a bottle, Ms. Craven breaking a bottle, or Ms. Craven initiating the contact with the victim. The only person who was called to testify, who was shown the video, was a defense witness who had no interest in the outcome of this case, who on cross-examination, well, don't you see that on the video? No, I don't. Don't you see that on the video? No, I don't see that. What I saw was X, Y, or Z. So we would respectfully suggest, if you take in the totality the number of instances where this prosecutor suggested, told, or flat out said to the jury, it's on the video. And I'll go to what I think may sum up and perhaps be as egregious as any of the examples. In closing rebuttal to the jury, quote, you now have a video that shows that they weren't acting in self-defense. That's the issue, self-defense. If it's not on the video about this popping and breaking of a bottle and lunging toward the victim, that's the entire issue that was litigated the first go-around.
So how's that different than any other closing argument? Both sides gets up for their closing argument, and they talk to the jury about the evidence, and they tell the jury what they think that evidence shows.
I fully respect and recognize every self-respecting trial lawyer should be arguing to a jury what the evidence has shown and show what the evidence has not shown, but not representing to a jury what is not in evidence. That's the difference here. If we go back to the Alvarez opinion, to argue to a jury that these detectives could identify after looking at
Well, I watched the videos, you know, both the enhanced, the regular one, all the videos that were in there, and you can't get a lot from the videos, and I think that a person watching the videos that had a certain view could probably see something that supported what they think was going to happen in any of your circumstances. I think you see what you want to see in that video.
Your Honor, I think what the court just said exactly sums up everyone's analysis of this situation. You see what you want to see if you're told what you want to see. And if I want to see X, I'll see
But there was
it.
eyewitness testimony to go with it.
But
There
it's
were the
not there.
participants' testimony. You know, the jury listens to these people and hears their words and looks at their demeanor, and they decide whose words to give weight and whose words to not give weight.
If I might, Your Honor, if the video, for example, or some other form of evidence corroborated what they were being told or what they wanted to see, but that's not what these videos do. I have heard repeatedly in reviewing this and looking at the arguments, well, it's murky. Now, it's hard to see. You've got to look really closely, and I respectfully suggest it's not there. So if I'm a juror and I have been told in opening statement, what you're going to hear about is on the video, and in the course of the trial, reference to the video, it shows this, and then to suggest in closing argument that the breaking of the bottle by the defendant and lunging toward the victim is on the video, by that point, our position is it is like Alvarez. You're just indoctrinated to that's probably what you're watching. And I don't need to worry about whether it's really on there or not. And that's the difference between where we were in the...
Well, on the other side, on the stand your ground argument, the argument was that Ms. Thomas was the aggressor, and that's not on there either. You really can't tell who the aggressor is by watching the video. The video doesn't really provide very much. It's murky and it's distant, and much of the time the people are blocked.
I agree with that, Your Honor. And so if one were to reread the trial court's order on the first hearing prior that went up on the petition for writ of prohibition, you will see the trial court say, I relied on the investigator who watched it countless times. He told me what's on it. And that's the problem with the whole issue. So I'll be the first to say, if there were no video in this case, and the jury heard from Ms. Thomas, and everybody went back and forth, cross-examined everything else, and the jury reached a verdict, fair enough. I couldn't quarrel with that. That's what the trials are all about.
So you started off by saying that the issue here is who was the initial aggressor. But couldn't have the jury found that Ms. Thomas was actually the initial aggressor, but the response by Ms. Craven was to up the ante to go from a brawl to using a deadly weapon?
I think the world, and this is a good example, is full of could-haves.
Yeah.
But in this particular instance, I keep in mind that the jury is being told over and over again, it's the breaking of the bottle. that got this going. You'll see it on the video, and it isn't on the video. That's what they're told over and over again. Sure, they could have found that anyone, Ms. Thomas or anyone else, was. So,
Do you think it mattered, the fact that Ms. Craven had some scrapes, but she was not injured in any serious way, and Ms. Thomas was severely injured, large and deep cuts in various places in her body that...
I think if the law in Florida ever becomes a measurement of the end result, it's going to change the state of the law. Because it could be in some instances, and we've all experienced it, where the person is entitled to exercise the self-defense immunity and kills the other person. Now, that's an end result that you would say, well, that's not, doesn't fit the circumstances that gave rise to the right to exercise the self-defense. So I'm not sure you could ever measure it by the end result.
Counsel, I'm going to extend your time because I think we have, panel has a few more questions. If Judge Roberts, do you have other questions?
No, I don't think I'm good. Go ahead, Judge.
If we could move to issue 1 on the challenge to the juror for cause, and the trial court excused the juror on grounds of really lack of memory loss, it looked like, and although that's not explicit in the record. My first question here is, did the defense adequately preserve an objection to the excusing of that juror? The only thing in the record that I see is the defense said that when the state really laundry listed all of the points that the witness had expressed regarding his lack of memory or problem remembering, the only thing I see in the record is the defense said he was speaking colloquially, and that nothing more, nothing that in fact his mind is sound or is not unsound. Why is that enough to preserve this for this appeal?
Well, if I could make 2 or 3 observations, Your Honor. First is that the burden under the statute, and I'm talking about 913.03, I would respectfully suggest is a really high burden. To say that somebody is unsound mind to the extent they cannot serve on a jury is more than, I couldn't remember what my wife told me to bring home for dinner last night. I mean, that's the kind of dialogue that takes place.
Do you have any authority in statute, rule, or case law that would suggest that that burden is extraordinarily high, as you say?
Well, I say extraordinarily high just by reading the language of the statute. It says, quote, is of unsound mind that renders him or her incapable of performing the duties. And I would point out there are 46 instances in this record where the juror specifically answered a question about different issues or events in his life or things that were going on right on target. I think it's 46 times. The only time he balked at it was one, about whether you testify in a trial, and he said, well, my memory could fail. I could be cross-examined and look like I'm lying, even though I'm not.
And I understand your point, Mr. Cox, but wouldn't you concede there is a point at which a memory issue of a witness would render them incompetent? Okay,
Yes.
so, and this is an area where the trial court has great latitude and discretion, and we have a lot of deference to give to that trial court's vantage point at trial. Isn't that correct?
I agree. They have to give deference on almost all issues in the trial court. The question is, does the appellate court grant deference in this particular instance, where all the trial court did was say, yeah, I saw that myself a couple times. That's all he said. He didn't say, let me question this juror. Let me find out if there's a reality, because he sure is able. Even the very last thing this juror said in this record was when the trial court said to the panel, look, we're going to think about trying this case on such and such a date. And right away he said, I can't do it that date. My son's getting married, et cetera. So as I said, 46 times, he's right on target. It's just these 2 little dialogues that took place that somehow rises to the level of this statutory violation.
And counsel, I'm going to extend your time by another 6 minutes. Judge Shane. All right.
Thank you.
You're welcome. And we'll also extend the time for the state.
Good afternoon. May it please the court. Oh, thank you. It's okay. Steve Woods on behalf of the state. I suppose if I could begin with issue 1, and beginning with as we were speaking about, the only attempt to preserve this was speaking colloquially. So, in other words, this is some sort of informal or inexact or exaggerated speech. This guy gets up there and he says something to the effect of, well, I can't remember what I said yesterday.
Well, so the objection to me was that this guy doesn't meet the standard under the statute to be removed for cause. That seems adequate.
Well, based on what he said, a reasonable person under the abuse of discretion standard certainly could have concluded that someone who gets up there and says all of these things, he gets up there and says 2 minutes after leaving the courtroom, I would remember only that I was in court and only that I was in jury duty. This is very specific. This is not stuff that he was speaking non-literally about. And the judge found that too. The judge is in the, as they say in alt, the unique vantage point to determine this person's credibility. The judge took all of this to be literal, and he said, I could, if I knew you, for years, if I knew you for 5 to 10 years, and I don't see you for 4 years, I might not know who you are. He says he might remember the previous 2 days. He candidly talks about his issue with
And
his
Mr.
memory.
Woods, and just to clarify, this was a 4-day trial, correct?
I believe so, yes.
And do you know how many witnesses were presented?
Many.
Okay, so this witness testified that he couldn't remember something, he might not be able to remember something that happened 2 days prior.
Exactly, yes.
What about Mr. Hanks's comment that he just made about 46 other opportunities for this man to lucidly answer questions? Doesn't that cut against this unsound mind, making him incapable of fulfilling his duties as a juror?
So he has 46 other opportunities to answer a question. I suppose what the state relies on here is the abuse of discretion standard. So our position is he can prevail only if he can show that no reasonable person would have concluded that this juror was of unsound mind. And given what he said, I mean, the briefest synopsis I can give is that he even said I would be reluctant to testify because of this condition. He forgets those whom he has known for years. And to say, if I left this courtroom and 2 minutes later all I could remember was that I was in here and in an oral argument, and gosh, I don't know anything about the case, I don't know the lawyer against whom I argued. This is a serious specific. This is not what the lawyer said. This is speaking colloquially in this, conversational, informal way, as if to say, well, he didn't really mean it. That's what
about the term, though? And I'm a little troubled by that term. I did a jet tour through the statutes and the case law and actually did it beyond Florida. Unsound mind seems to me to be someone that's not able to carry out their own affairs. I mean, that's one of the many reasons behind someone being unsound to carry out their own affairs. Help us understand if there is authority for memory loss, potential memory loss, being enough to qualify as unsound mind, because that's what the statute says. You would agree that's the term, correct?
Yes, sir. The statute does say that. The
All right.
statute says in subsection 2, the juror is of unsound mind. So we rely on different language in the statute, unsound mind, such that it renders him incapable of performing his or her duties. And if he cannot recall what is being said, or if he can't recall what is on the video, then that would have rendered him, that would have been a reason for the judge to grant this for-cause challenge. And the totality of what he said, our position is it establishes it with complete clarity. And all we have to show is merely
And this
that
may
it's-
be a tougher question, but the term matters. The term matters because that seems to be the basis of the objection. And this may be unfair, and I apologize for it if it is. I did see this was a 1939 statute. It went back to 1939. Was that term, did that start in the 1939 statute, or do you know the answer to that?
I don't know the answer to that.
Well,
Your Honor.
and the reason I ask that is, do we need to go back and look at what that term meant, was that 70 years ago, 80 years ago?
Our position would be the juror is of unsound mind. This doesn't say that he is of unsound mind to the extent that he's unable to perform his abilities as a juror. And in this case, I think all you would need to show is that his mind is unsound such that he couldn't recall the information. As Your Honor pointed out, this 4-day trial with many witnesses, a video that has to be paid very close attention to. And this is someone who talks very candidly about forgetting people he's known for 5 to 10 years. Someone who can't remember what he was doing that morning. From what he swore to under oath, and this is not speaking colloquially, he meant that he could not tell you anything about what was going on in court other than he was in court and in jury duty. Those are his words, and they were specific, and they were not an exaggeration, and that's apparent from the transcript. The trial court,
I've got another question, maybe a couple more questions. The statute starts out, a challenge for cause to an individual juror may be made only on the following grounds, and obviously the subsection applicable in this case is unsound mind or has a bodily defect. And this is a hypothetical. Suppose you had a sleeping prospective juror, someone in the venire who's sleeping. That may not be unsound mind, but would Mr. Cox or an equally very qualified trial lawyer have the ability to say, I want to strike this prospective juror for cause, even though it's not captured within the statutory framework?
under those circumstances, I mean, if he were incapable of staying awake, yes, because he would be of unsound mind such that he would be incapable of performing his duties. In other words, staying awake, receiving the information, retaining it, and making judgments about it. In this case, of course, the problem is not that he can't stay awake. The problem is that he stays awake. However, he cannot, as he said, the information don't stick in. He goes on to say, I have great difficulty remembering names. I can't remember information.
Well, let me ask the question a little differently, and I certainly understand your answer, appreciate your answer.
Thank you.
Are we limited to the reasons captured in this statute? Or is there some other discretion a trial court has that we want to encourage trial judges to carry out in evaluating prospective jurors? Or does this statute say to us that if it's not in here, you don't get a for-cause challenge?
Your Honor, as you pointed out, the first sentence may be made only on the following grounds. The statute says what it says. The state's position would be that unsound mind, one can be of unsound mind in several different ways. You could be of unsound mind for any number of different mental health issues. You could be of unsound mind for an inability to form memory. You could have a short-term memory issue. This person may have had both a short and a long-term memory issue. The unsound mind, I think, that term it sheds light upon it later in the statute. It says, incapable of performing the duties of a juror. So if he can't take in this information and retain it, he is of unsound mind within the meaning of 913.03 subsection 2.
What about another hypothetical, and we see this sometimes in the trial court, a disruptive potential juror, someone who's argumentative, showboat, wants everyone to think in his or her mind that they're the smartest person in the room, and they just monopolize the time and voir dire, and the parties say, enough of this person. Does that fall within the statute, and would the trial court have the ability to grant, let's say both parties said, this person needs to be stricken for cause, or would they be of unsound mind?
Well, I suppose that hinges on whether he is, if he is capable of not being disruptive, then he's not of unsound mind. But if he truly has some mental issue rendering him incapable.
So the rules whether to keep or dismiss a juror, is that a substantive law or is that a procedural law?
Well, if you were to I suppose our position would be that the unsound mind, I suppose I'd call the Court's attention back again to the standard of review. I mean, a reasonable person, it is possible that a reasonable person could conclude that this person, you know, did have an unsound mind insofar as he simply couldn't retain the information. In order for the appellant to prevail, you'd have to say, no, it's absolutely impossible. No reasonable person in the universe could look at this man who forgets people he knows for years and years, this man who, you know, he's in court and 2 minutes later he knows only that he was in court and only in jury duty. Like I said before, the comparison to this is if I spoke to you out in the hall afterward and I said, you know, I remember I was in court doing an oral argument, and I remember, what do I say? I remember I was in court and doing an oral argument, but I don't know the case. I don't know anything about this. I mean, that is a serious, I am of unsound mind to be a
Mr.
juror.
Woods, yeah, so let's talk a little bit about the procedure and then, and how the trial judge is supposed to discharge its duty to determine whether someone should be excused for unsound mind. So if we look at, you know, whether a defendant is of unsound mind, there's an entire rule and process, and Doherty tells us exactly what a trial judge should do to evaluate the competency of a defendant. For witnesses, you have the impeachment process to demonstrate that a witness may not have the mental acuity to serve as, or to be credible. When it comes to the competency of the juror and their mental ability, you're really left with this statute, it looks like, and then Rule 3.330, which is the trial court shall determine the validity of a challenge. And in making such a determination, you know, there may be material witnesses that are produced by the parties or examined under oath, and consider any other evidence material to such challenge. Here, the only thing we have is the observations that the trial court makes of the witness and the argument by counsel, right? So certainly there are other things that could be done if we're talking about one of these extraordinary examples, and you know, the defendant is challenging the state's for-cause strike. But practically speaking, what other things could and should the trial judge do in this situation?
Well, I suppose here the trial judge could have allowed further questioning. I mean, the defense lawyer could have said, you know, did you mean that literally? And the answer would have been yes. I think he didn't pursue that line of questioning because it was so obviously specific, literal testimony. And I guess I'd also mention that, you know, this is the trial judge determining the credibility, and, you know, as we know, the appellate court cannot second guess what the trial court has determined from its unique and superior vantage point. He sees what is being said, and he sees things that aren't in the record. So he's able to evaluate this person just like a trial judge is able to evaluate a witness and make a determination of credibility. Here, the trial judge heard that, and he found it to be he found it to have been literal, and based on the literal nature of the statements, he concluded that that juror was of unsound mind and incapable of performing his duties as a juror. In this case, I mean, this is not a case in which you have, you know, some cases, of course, can be only one witness, or some cases can be much shorter. This is not an extremely short case, and this is not a case with a remarkably low amount of witnesses. This is a divergent accounts of the same incident. And as you mentioned, with the video, it requires you have to watch the FDLE enhanced video, and you have to watch it over and over again, and you have to pay attention, and of course you have to remember what you saw. And all of that, Mr. Newell could not have done based on his statements, that basically his ability was so limited to recall with respect to his short-term memory. Again, not to repeat myself too often, but only that he was in court and only in jury duty, and none of the details. So, I mean, if he couldn't remember any of the details, he was certainly of unsound mind to serve on the jury.
If you would move on to issue 3 and the stand your ground argument that Mr. Cox has made. So as he pointed out, there was an original stand your ground hearing that came up to this court on prohibition, and that petition was denied. But then a key, or at least as the appellant argues, a key piece of evidence was then eliminated through the motion for in limine before trial. But did that leave the state without any evidence to prove this case?
Our position is no. Respectfully, I mean, first we have, you know, there is the stand your ground hearing under 776.1 .032. And the question of this is, whether this person is entitled to immunity. So the trial court denies this, and it's affirmed by this honorable court, and it's over at that point. The question then was, does he have immunity? He is at trial. And then, of course, once you're at trial, the question is one of guilt or innocence. And so we talk about it's excluded, the testimony of Jake Brooks. He cannot get up there and he cannot say the video establishes this, the video establishes that, because that would be invading upon the province of the jury. Our position is the video to me and the video to the state, it does show, it is the state's best evidence. And I'd also point out that in the case that Your Honor referenced, in the when this court affirmed the denial, the trial, when this court ruled on the writ of prohibition, the language out of that case, this court said that, the security footage shows appellant extend her arm away from her body, appellant move her arm against a nearby vehicle, appellant bring her arm back toward the victim and grab the victim by the throat and strike the victim multiple times while the victim attempts to back away.
All right, so understanding that, counsel, isn't the appellant's argument essentially that there wasn't a sufficient quantum of evidence to prove that Craven wasn't entitled to immunity? And if that's the case, why doesn't Boston answer that question?
Well, our position is Boston does. I mean, supposing, there had been a problem with what happened in the stand your ground hearing, supposing there were an issue and it somehow cast into doubt the contention that, the state proved by clear and convincing evidence that Mrs. Craven was not entitled to immunity. That is muted, that is muted and subsumed by the guilty verdict because, of course, beyond a reasonable doubt is well above by clear and convincing evidence.
And as Mr. Cox correctly argues, in Boston there was a different, the wrong standard of proof was used. That's not the case here. So why should Boston extend to these circumstances?
Well, first, the first thing I would point out is that the fact that at trial, they excluded the testimony of Jake Brooks. So at trial, the jury doesn't get to hear about this. This is after the fact. This is after the stand your ground hearing. At the stand your ground hearing, that question had been resolved. The trial court denied it, and this court affirmed the denial, and that is law of the case. It is done. He was at trial because he didn't have immunity. The question at the stand your ground hearing is whether he's immune. The answer was no. All of that is over and has no relevance once it comes to trial. When we are determining whether, she can have the self-defense defense, she can say, she can have the prima facie case, and then that will have to be.
So in a lot of these cases, it seems like that the so-called stand your ground, the self-defense immunity hearing is often deferred to the trial. They don't have it ahead of time. And I argued in concurrence that the whole right given by the self-defense immunity is the right to not go through this long process. If you're asserting self-defense, you get an early ruling. But they heard Boston back in May, and they could rule. So do we need to, depending on which way this goes, do we need to cite to Boston to give them, or was there another self-defense immunity hearing at trial, or was there only the one self-defense immunity hearing, and at trial you just had a trial with a defense of self-defense that was raised?
Your Honor, our position would be that there would be only one self-defense hearing, and after that question has been decided, and after it's been decided at the appellate level, it is simply over, and it is determined that there is no immunity, and that is the reason a person is at trial.
So immunity was decided, that goes away with or without Boston, and you're at trial, and it's just like it was before they created self-defense immunity. If you feel like that you acted in self-defense, you raise that, you have to present a prima facie case, and then the state has to prove that you did not act in self-defense to the exclusion of every reasonable doubt.
Yes, sir.
Okay.
As many of those cases say, the fact that you lose, of course, at the stand your ground hearing does not mean that you can't raise the self-defense defense at trial.
Right.
And she had that option, and she took that option, and our position is the video is what sunk the ship.
So do you see anywhere on the video where she broke the bottle? Did you see that on the video?
Yes,
Really?
yes,
Okay.
yes.
Can you give me a timestamp on that?
Yes.
Because I'd like to watch it again.
Your Honor, this is, let's see. This is on there are many videos. This is the FDLE enhanced video, the one that runs 3 minutes and 55 seconds. If you have the same CD we have, it is the second file. And in the beginning of our facts section, it goes through a brief chronology. Okay. $2.26 on the FDLE enhanced video. And then the
2 minutes 26 on the FDLE enhanced.
Yes, sir.
Thank you.
Yes, sir. And then the physical fight begins seconds after that, and you can see, as testimony touched on this point, the victim does swing back, does retreat, and this is one of the things that's argued during the closing statement. The state attorney says, well, look, it's clear as day on the video that when she takes that countermeasure strike, that defensive strike, that bottle came nowhere near the appellant. Then when the victim is off balance, she is charged, struggle ensues, and then she is attacked. And of course you have the injuries too, and I think as one of your honors brought up, they say that, well, this all hinges on self-defense, but self-defense gives you only the right to use the force that is reasonably necessary. And that is not what happened here. The injuries in this are horrendous. This is a repeated, vicious, malicious stabbing. This woman, the testimony, I don't want to belabor you with too many details, but it is horrendous what happened to her. How many times she was stabbed, her ear was amputated. You hear testimony about puddles of blood, spraying blood. She had to be life flighted out. This is not as if she's under attack and does one strategic strike and retreats. This is
Mr.
not.
Woods, you're over time, but I'll give you a few seconds to wrap up.
Thank you. I'm sorry. This is not what was reasonably necessary. This was far more. And thank you, Your Honors.
You're welcome.
Thank you.
Madam Clerk, if you'll please add another minute and 26 seconds to Mr. Cox's time, please.
Thank you. May it please the court.
So, Mr. Cox, are the rules regarding excusing jurors, is that procedural or is that substantive?
For cause, substantive.
Yeah,
I would say
substantive.
substantive is for cause, yes.
Okay.
Because I believe every person is entitled to serve on a jury as a citizen of this country, so it would take some legislative act to override that. That's Mr. Cox on the subject.
No,
Substance
we,
versus procedure.
sometimes that can be an authoritative source.
I just want to respond briefly to Judge Jay's question, and I'll use the term antiquated statute, if it is, which was used here, or which is in play here. I believe the Second District Court of Appeals already answered most of Your Honor's questions in a case called Crawford v. State, which is on page 24 of our brief, where they had to deal with whether a juror whose medication was causing drowsiness was a basis for cause. All right? She wasn't of unsound mind. She just whatever. And the court found that a juror who is absenting themselves from participation in the trial is a basis for cause. So it fit within that Second District Court of Appeals analysis for cause issues. And also, I know Judge Rowe had asked the question about what steps did the trial court take once the issue arose. You have the rule of procedure that says do A, B, and C, or that's available. And obviously here it was just very much, well, the state said we moved for cause because he can't remember X, and the judge says, yeah, I had some same concerns. That was it. There was never any discussion about whether this person was or was not of unsound mind. There is a dialogue with this juror that takes place when the state raised the issue of principles. Do you agree with principles? Keeping in mind, the trial court had not instructed the jury on what the law of principles was, and he gave this astute analysis of, look, if I go into a convenience store to rob it with somebody else and they take out a gun and kill somebody and I didn't know it was coming, I don't think I should be getting that same penalty. That's the lay analysis of principles. That person is not of unsound mind in any of the examples he gave. And secondly, with the Applee's comment about what is on the videotape on the Applee's brief at page, if I might, page 1 of Statement of the Case and Facts, going on to the top of page 2, the Applee recites different instances of what is on the video, and I respectfully suggest almost none of those are on the video. That's the problem with this case, and that's the problem with jurors who are influenced by what's going on by, and we didn't cite the law, but I know the court's familiar with it. Sometimes when someone who has peculiar knowledge that they think has, they must know. That's their business. They must know the answer to that. And that's what happened in Alvarez. Well, the detectives must know whether that's an African-American or Hispanic in the pictures. We don't know. We can't tell. And the appellate court reviewed it and said, we can't tell either. We're not going to allow that to happen. So, thank you.
Thank you, counsel. Thank you both. Again, this court is adjourned, and counsel is welcome to join us in the rotunda.
All rise.